And thank you very much. A warm applause for Marielle.
Thanks. So I realized I'm a minority here. I'm not only a woman, I'm also a lawyer. So I think I'm the only lawyer in the room. I don't know. But I'm here to talk about the new General Data Protection Regulation, GDPR, which you all heard about now that Lucas mentioned it before. I'm a lawyer at Delphi law firm. It's a national Swedish law firm, and we've got offices here in Gothenburg as well as Stockholm, Malmö, Norrköping, and Linköping. So we're one of the biggest law firms in Sweden. I am working as a specialist in IT law and now very busy with compliance work as regards to the GDPR. So that's what we're going to talk about today. I will give you a short introduction about the GDPR in general, and then we will discuss the security requirements and privacy by design a little more. We often give lectures for a day or two, so as you might understand, we don't have time to go into details today. But I think this will at least give you a general overview that you need. So this is a new EU regulation that was adopted in May this year, and it will enter into force on 25th of May 2018. And it will replace the current data protection directive, PUL, if you know it in Sweden, personuppgiftslagen. And it will apply for all EU companies and public bodies in EU. And also actually to companies selling to the EU. So not only European countries, you can't have your company in the US and sell to the EU and that way not have to comply with the regulation. So that is a wider scope than before. Very exciting. And why do we have this new GDPR, you might ask yourself? Well, the Personal Data Act, personuppgiftslagen, and the directive came in the end of the 90s. And you who work with IT know that a lot has happened since the end of the 90s, right? With Internet of Things, big data, all the buzzwords at least a couple of years ago, and we're still talking about it. We need some new regulations to protect the privacy of individuals. So that's why the European Union has adopted this new regulation. And why do we talk so much about the GDPR? Since we have already rules today. We have the directive. Now with the GDPR, we add a few new rules, and then we sanction the package with up to 20 million euros or 4% of the total annual worldwide turnover for companies. It will be the highest of these two. So now you understand why big companies and small are starting to work with privacy, because we have a lot of these rules already today. And then you also risk damages, penalties, so the administrative fines are only one part of it. So this is the new GDPR. The GDPR is coming. Well, but when does the law apply then? Because all of you here work with data. This only applies to personal data and the processing of personal data. So when I say data during my presentation, I will mean personal data. Please have that in mind. So what is personal data? That is any data that you can identify a person with, either directly or indirectly. So of course it's your name, your email address, even the email address to your work, like mine, marielle.eide@delphi.se. That's personal data. And also IP address, car registration number if you work within the car industry. Anything that you can connect to an individual. And encrypted data is also personal data. So now we have that clear. Because all IT people, but we encrypt the data, so it's not personal data. Well, it is, because it can still be connected to an individual with a key. If there is a key somewhere, it is personal data. So if you anonymize the data, it's not personal data. But as long as there is a key somewhere, it will be personal data. And it applies to processing. And what is that? That's everything. Storage, collecting, anything. I'm going to mention a few key definitions that you need to know about. Have you heard this before? Data controller, is that common to you all? A few nods. I think most of you don't know. Data controller is the person, legal person of course, if you're representing a company, who determines the purposes and means of the processing of data. And that sounds like legalese, don't you think? Well, purposes and means of data is who decides if we're gonna send this this newsletter to someone, if we're gonna we need the email address to do this and that. We're gonna use cookies and we're gonna track our users. Whoever decides that is the data controller. And why do you need to know if you're the data controller? Well, it comes with the second bullet point. The data controller is always responsible for the compliance with the law. So you can't say that we have an IT supplier which provides us with data backup, so we're not responsible. They should know what they do. No, you're master of data if you're data controller. You need to know, you need to comply with the law, and you can't say that it was the backup company, they should have done this, or Microsoft, or whatever. So this means that all companies are actually responsible for that the IT systems meets the legal requirements. You can't blame it on the supplier. So what is the supplier then in this relationship? Well, the supplier is the data processor. The data processor is a person or company who processes personal data on behalf of the controller. So only in accordance with the data controller's instructions. And it's always someone outside the organization. For example, IT supplier is one of this, but it could also be a consultant who works at your company's office that comes in. You can have IT support from India is quite common, but it could also be someone else in Sweden. So you always need to define who's the controller and who's the processor. And that's to know whose responsibility is it to comply with the law. Actually, with the GDPR, if you are a controller and you know the rules, I also want to say very quickly that now there are also some processor obligations. Before it's been strict, the controller's responsibility, but now if you're a processor, you also need to comply with the law. There are certain obligations that actually apply directly to the processor. We don't have time to discuss these today, but I hold seminars regularly, and you can also read about it online. In some cases, it could be that both the parties are controllers and processors. And when is that? Well, for instance, if I as a controller ask you to process email addresses for my customers to help me send out newsletters, that's a very simple example. And you do that, then you do it on my behalf. But if you also then start using the information for something else, statistics, maybe monitor patterns or whatever, then you become the controller in that situation. And if you have a processor, you need to remember you need a processor agreement. So if you have these in place, you need to update them. If you don't have them in place, you need to draft them. And the processor is a legal entity, not so the individual has a relationship with the controller, and the controller will use maybe the processor for IT support, for instance. So, and there's a relationship there. Integrity stare. Why do I show you this? Well, it's because I meet a lot of IT officers who only talk about security. And that's the fifth step of the stairs. You need to have in mind that you need to go all the steps. You can't just say, well, now we have a super secure solution. Now we are in compliance with the GDPR. You need to go through all these steps in order to make sure that you're compliant. You understand? Yes, you're a very quiet crowd. Thanks. And the first step at all is to ask yourself, is the processing even legal? And that's a bit what Lucas spoke about before. Actually, you need to make a legal assessment, whether you can do the processing at all before you do it. There are also a set of fundamental principles that you need to make sure you comply with. You need to sort out data in time. You can't process more data than what is necessary for the purpose of the processing, and so on. If you process health data, sensitive data, or information about religion, about sex, then it's sensitive data, and there's additional requirements relating to this. Also for security. You need to give information to the data subjects. Usually that is done in a privacy policy. And then comes security. And then there's all these exciting things like agreements that we lawyers work with. You need to have documentation, example for your privacy impact assessment. And then you also need to consider where the data is being processed. So we're not going to talk about all these today, as you might understand, but I wanted you to have this in mind. Something that is important in order to make an assessment whether the security is proper or not is to have a few basic principles in mind. So that's why we're going to talk about that. This is the first step in the integrity stairs. Data should only be processed when it's necessary for compliance with legal purposes of processing. This is quite the opposite of how we are working today. Today, companies select more data. We need all the data. We collect everything, we save everything. We want to do as much as possible. Maybe we have the next idea or big breakthrough or something. So it's big data age right now. But you shouldn't process personal data unless it's necessary, and that's a very basic principle. I work a lot. I'm a consultant, as you know. Lawyers, we work with our clients. And a lot of companies say, I ask, why do you process the personal identity number if someone purchases a product? That's quite common today on the web. And they say, we've always done that. Well, okay. Is it necessary for you to deliver this jacket? No, we want it just in case. Well, that's no more, so to speak. And then we have different grounds for when processing is lawful. And the most common one is that you have a contract. Because of course you can process data if you have, for instance, online. I work a lot with e-commerce companies. If you buy something, of course the company will need my address and my name in order to deliver the things that I bought, for instance. And that is, most companies can rely on that one. And then it's also, if it's necessary to comply with the legal obligation. Now, maybe it's no one here working in the finance department of your companies, but for instance, in order to, you need to save data to comply with bokföringslagen. I don't know, 7 years for that purpose. So that could be one of those. And if you don't have a contract, if you don't have a legal obligation, you usually you end up in bullet point number 5, and that is that you make an assessment of the interest, and you weigh the interests of the company and the interest of the individual and its right to freedom and privacy. So it's not only consent. That is the last and final way out. You don't need consent for everything. Because that's also something I meet a lot. Okay, now we're going to process personal data. We need consent. No, you don't need consent for everything. And that's important because now that you need, the regulation will impose these rules that are even stricter than before. You don't want to have consent. Maybe if you purchase online, or if you buy, you're downloading an app on App Store, you don't want to have to click 15 consents. And that's not good if you want to sell something. You don't want to say yes, 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 yes. You're not going to get your consent. So that is important. So how do we make a legal assessment? Well, first step is to ask yourself, what is the purpose of this processing? And what is the legal basis? If you don't have this, like I said, you need consent if you don't have a balance of interest or a legal obligation, etc. Well, what is necessary for performance of a contract? I already mentioned that. If you're gonna, I mean, you can apply this to everything. But if you have employees, of course, you need to process the hours they work, or if they're being sick, you need to do that in order to pay their salary and to fulfill your obligations as an employer. I've written a few principles here, and this is also because these are key principles in the regulation. So minimization of purpose is the data never should be processed for a purpose other than for which it was collected. So you can't actually collect personal data for direct marketing purposes and then you use it 2 years later like, well, now I want to use this for something completely different. I came up with this brilliant idea what I want to do with this data. That's not legal. Minimization of data, that's the opposite of how we've been working today, right? And the data should be adequate, relevant, and limited to what is necessary for the purpose for which they are processed. Legalese again, right? So, for instance, that is, you don't need social security number to deliver goods, for instance. And also, another very important principle is the minimization of storage. You're not allowed to keep data longer than necessary. I meet companies, and this is very common today in Sweden at least, that say, but our data, I met a company yesterday that said, but we have data that is 25 years old. We keep data from beginning of the 90s. And that's very common. I guess most of your companies do that as well, unless you've been working very actively with the personuppgiftslagen, PUL. And most companies haven't, because there hasn't been any need for that, because it hasn't cost the companies anything to do something wrong. But now it will. So we dive into the security requirements, because there are security requirements under the GDPR, and I guess that's what you're interested in hearing. Well, the requirements under the GDPR are very general and high level. It's general requirements and principles for security. Why is that? Everyone here, I guess, wants me to tell exactly how you in your organization should work with security under the GDPR. And I'm very disappointed to say that I can't, because no one knows that yet. And why is that? Well, that is because this regulation, like I told you a few minutes ago, applies to all companies and public bodies within the EU. And that means that pharmaceutical companies and banks also have to comply with these rules, as well as a small startup company of 2 people that developed an app, for instance. So thank God that it isn't detailed. The devil is in the detail, so to speak. So that's very good. And this is what it says, that the controller and processor, you remember what I told you, shall implement appropriate technical and organizational measures to ensure an appropriate level of safety for data that is being processed. So it's both technical aspects to consider and organizational aspects to consider. And the measures should provide a level of security that is appropriate with regard to the latest developments in technique. That makes sense, because we're actually going to live with this regulation for quite a while. So it's good that it doesn't say certain technical aspects that we have right now, because it's changing every day. Also, with regard to implementation costs. And that's good, because IT systems are expensive. So you can consider that. and also the nature of the processing, the context and purpose of the processing, and the privacy risks. Like Lucas mentioned before, I am not an expert on security. You guys are. You know a lot more than me on security. I'm an expert in law. So these assessments must be done by people with your background. What are the risks for privacy? So you can expect to work on this in your companies, I guess, the coming years. But the regulation actually gives a few examples, at least, on what you should consider. Pseudonymization and encryption of personal data, for example. Do you all know what pseudonymization is? Yes. I can at least, if someone doesn't know, it's not the difference between pseudonymization and anonymization is that with pseudonymization you still have a key somewhere. So for instance, you can, if I have a register of personal data, and I can ensure a higher level of security if I, for instance, instead of having all your names in the system, which any user can access, I can change it to person 1, person 2, person 3, etc. And then on a separate list or separate system somewhere have a key to match. That's pseudonymization, at least from a GDPR perspective. And encryption of data is also a good way of getting better security, of course. And then there are these fluffy wordings that it's hard to, at least for me, to see exactly what it should be, but you should, for instance, have the ability to ensure the ongoing confidentiality, integrity, availability, and resilience of systems. And also ability to restore personal data and access to personal data in a timely manner if there is a physical or technical incident. And also, you should work with this on a regular basis by testing, assessing, and evaluating the effectiveness of the system and the measures that you have taken for ensuring the security. So this is not easy to work with, right? Or do you know exactly what to do now? Yeah, get to work. I'm leaving. Well, so we don't actually know exactly. But what we do know is that you should have a risk-based approach, and this is nothing new for you security professionals, right? And that is key. And so you should consider the risks and which are presented by the processing. And actually, the regulation pinpoints a few things that are of importance, such as loss of data, alteration of data, unauthorized disclosure, access to data, accidental and unlawful destruction of data. So, for instance, what will happen what is the risk if I process, for instance, health data, if it's lost? What should I do, and how can I, perhaps if it's decrypted, can I use decryption in some way to ensure that if it's lost, the integrity risk will be lower, for instance? Unauthorized access to data is, I guess, what you work with daily, and how to prevent that, and what you do if that happens. That's also something you need to keep in mind. To demonstrate compliance, you will be able to follow code of conducts that will be presented. They are not yet, so you will actually get some guidance. The European Commission will draft code of conducts, as well as the supervisory authorities in Sweden and rest of Europe. So there will be some guidance quite soon. I have a picture which is good for, I think is good at least, to show what the security requirements under GDPR is. So it's both technical and organizational measures, like I told you. What are organizational measures? It could be your IT policy, for instance. Who should have access to the system? Do we have we don't let strangers into our building and use our systems without them writing a confidentiality agreement or undertaking. We have this reporting system. If something happens, we do this and that, etc. That's organization, and that's also part of security, like you know. And also the technical measures, which are different depending on which data you are processing. Of course, that's always where your starting point. What kind of data am I processing? If you're a business-to-business company, everything you process is the email to contact persons in your, for instance, in your customer. If you sell to legal entities, that of course doesn't need the same kind of security measures as if you're a hospital working with patient data, for instance. So it always starts with what kind of data are we processing, and then you need to identify what security measures you need to take. What is also pinpointed, like I mentioned, are the procedures for monitoring security. You can't only fix the security and put in place everything and then not monitor it, of course. This is good. Security level in relation to risk is exactly what I mentioned just now. So is that crystal clear? Yes. Well, I think you're lying. Well, but let's get a little more hands-on by talking privacy by design. Why do we have rules about privacy by design? Actually, in the new GDPR, there is an article in the GDPR which is about privacy by design and privacy by default. Why do we have this? Well, actually, it's because most companies today say, well, privacy and everything sounds nice, but our system doesn't support that. That's the most common comment we get from our clients. Our system doesn't support erasure of data, so we can't do it, sorry. Well, that's not good enough anymore. Now you need to consider privacy throughout the entire life cycle of an IT system. So for systems that are procured today or developed today, you need to keep privacy in mind. That's something new. And this means, of course, that the data controller, who is in charge of the data, shall decide what requirements are put on the system. So you need to make a privacy impact assessment, a legal assessment, before the system is purchased or developed, which is new. And also here we will get some implementing acts regarding how we should interpret this, and also come with some technical standards, which is good. Today, if you want to read some more, I have another slide about privacy by design, but I can already tell you the Canadian Privacy Commissioner has written good reports about privacy by design. They are a few years ahead of us here in Europe, in Canada, so you can check that out. Also, Datainspektionen, who is the supervisory authority, has some brief guidelines as regards to privacy by design. You can Google it. And also ICO, which is the British supervisory authority, have some guidelines on privacy by design. And that's about it, what we've got today. So it's very brief. But of course, there are a few things that we can say already and that I mentioned already. So how do we achieve privacy by design? Well, for instance, you can work with data minimization. Does everyone see what it says? Because it's quite a big... Yeah, you have good eyes. That's good. Data minimization. You shouldn't design a system so that it collects more data than necessary. You don't insert more fields than what is needed, for instance. So you shouldn't have the address to someone that you don't need the address for, and so on. And also minimize free text fields. Can you guess why that is? Today, a lot of companies fill out lots and lots of information in free text. Avoid that. Remove free text field unless you really need it. Of course you should have it if it's essential for the business or you really need it. And if you do have free text fields, have an IT policy and educate the employees on what to write in free text fields. She's an idiot. No. Or, this person wanted to extend the time for paying for something because she's in a divorce, or she's sick, or her mother is sick, etc. There's been several cases on this already. So watch out if you have this. Also, if it's possible to anonymize data, do that. Is it really necessary for everyone who uses a system to see the individual behind it, or to connect this to an individual? A lot of data that we analyze and process doesn't actually have to be on individual level. It is enough that it's on an aggregated level, or at least on an anonymized level. So consider that. Is that possible for us? And restrict access to data. This is common. Yesterday I met two companies. Both said that, well, all our employees get access to everything. They work in the warehouse, they get access to history that is 25 years old. Well, you're here. But restrict it. If it's data that only the finance department needs to see, then restrict that. Then enable that in your systems, that you could restrict the access to different functions. We've already mentioned encryption, backup logs, and erasure of data. Well, I don't think I need to say anything more about that. Authentication and access control functions need to be built in the systems. You also need to have functions so we can go back and see who opened this document and who did that. I can't find the word for it now, but a log, for instance, that could also be necessary to have. And data can't be processed for eternity. I already mentioned that. And why is that? Well, you can only process data as long as it's lawful. That we've already discussed. And it is lawful to process data, for example, if you purchase something. But when you have delivered the goods, you don't have any legal ground for processing anymore. What should happen then? Erasure of data. Unless you have another legal ground for processing. That could be, for instance, marketing purposes. You can keep the email address even if you don't have consent, for at least with the court cases we have now. You can process that for a year or so after. But after 1 year, it should be automatically deleted. And this needs to be built in the systems. Do you have this in your systems today? No one. Most systems do not have this function, and if they do, they are not used at least. So this needs to be done. And also default storage settings. If you start by assessing what your legal ground is and how long you can process something in accordance and compliance with the law, you know that, well, we will probably be able to process this, say, for 3 years. So then have default storage settings. After 3 years, data is deleted. And also, data subjects, they can actually request information of every personal data about them that is being processed by a company. Do you have IT systems that support that? That is actually really expensive. I met a woman who's working in a British law firm the other day, and she said that they quite often get requests where the data subjects asks, well, what data is being processed about me? And they need to find in every system, even in the email, and a list with all personal data about that individual. And she said they spent, it was about 50,000 euros or something for that. And we can expect that individuals will probably be more informed, because we have this right actually already today. Has anyone used that? Yeah, quite a few. This is actually the most people ever. So you're expensive for companies. It's very expensive. Most data subjects don't know they have this right. And actually you can only ask for 10 euros, I think it is, in compensation from a data subject for this, the exercise of this right. And today under Swedish law it's actually for free once yearly. So if you want to harass a company, you know how to do it because this obligation is already here. But that function should be in the system. Privacy by default is another principle that we have. So data protection by default, and that is the default settings of a system. For instance, access, like I mentioned before, automatically erasure of data, and this applies to the amount of personal data. By that I mean, of course, what kind of data is being processed. Privacy by default and privacy by design are closely connected, so it's at least from my perspective, it's hard to draw a line between what belongs to what. But default settings that are made to comply with data protection. So it's clear that data protection and privacy law should always be in mind if you have a system that processes personal data. An IP address is personal data, remember? So this doesn't only apply to names and so on. It applies to a lot of systems, at least. Let's see. We have good time. Well, this one is also interesting. It's not a maybe security function, but a security measure. From now on, you will have information requirements on personal data breach. Hacker attack, for instance, that's one of them. Or if one of the employees at a company lose their computer or mobile phone, that's also a lot of personal data in a mobile phone, right? If there is a personal data breach, the controller needs to notify the supervisory authority with undue delay. And that is by general rule no later than 72 hours after becoming aware of it. So this, if it happens Friday night, this needs quick action. So you need to have IT policies in place on what to do. And you need also to get an alert if this happens, right? In the system. And the worst part of it is that you could be obligated to notify every data subject to inform. We have, it seems like we have lost your personal data, we've had a hacker attack, and this could mean this and this and that for you, your security and your privacy. And no company wants to do that. That is bad will. That is bad will. But you don't have, if it's a disproportionate effort, you can instead have a public communication, which could be, for instance, your press release and on your websites and so on. There is an exception, though, thank God, and that is if there is a system to prove that the lost data or data that have been affected by the breach has been made unintelligible through unauthorized, for example, by encryption. So that's the security measure in this. So that is good to know. There are many other news in the regulation. It consists of 99 articles, and we've spoken about 1.5 briefly. So you might understand there's a lot more to say about this. We've spoken about, Lucas mentioned privacy impact assessment. That is one requirement. You should have functions for data portability if the data subject requests to move the data from one system to another. For example, from Facebook to a new social media site, that should be possible. You have the right to be forgotten, so you need to have functions also to erase a person and its data from the systems entirely. Not just say, well, you don't get newsletters anymore. Well, total erasure. Unless you have a legal ground for processing, of course, then you don't need to erase the data. So that is, we've only touched upon the surface. So what does this mean in practice? Well, on a high level, this means that due to the high risk of administrative fines, privacy is now a question for top management. And it's more important to comply with the law, of course. We need to work preventively. We haven't done that before. We've been working the supervisory authority knocking on your door saying, well, should you really process data in that way? Should you save it for that long? Well, now we need to work beforehand. We need to show that we have, when we develop the system, when we purchase the system, for instance, we need to show that we made an assessment. Our assessment was that this system actually, it complies with the law and so on. So accountability is important. And budget is necessary, of course. This costs a lot of money. This is also to illustrate the complexity of compliance with the GDPR. I'm a lawyer, like I said. I work with the two boxes on the top: legal assessments, drafting of legal documents and policies, etc. But you also have the technical measures that you all guys work with, privacy by design, etc. And then it's organization and routines. So you need to work together, and we need to work together to comply with the GDPR. If someone comes and tells you, I have a system and it will make you comply with the GDPR in a minute, then you should watch out, because it might only be one sentence in one article in the GDPR that it helps you comply with. And so my last picture today is how can we prepare? Well, the first one is for your companies to budget and plan, create awareness. It's very good that you're here listening to me today. You also need to raise awareness internally about these rules, and also investigate, make a gap analysis. What do we need to do before May 2018? And your companies need to conduct a compliance project where IT measures is one of the bullet points of that. So now what can you do today when you go back home? If you can, raise this question and educate your organization about privacy by design if you're working in the IT department, and how important that is, so you at least start in one end. And if you're purchasing an IT system, have in mind privacy when you procure the system. Otherwise, it won't comply with the GDPR in 1.5 years. And it's a big investment to buy an IT system. We all know that. So you need to be one step ahead. And also, data processing agreements, for instance, need to be updated. That's also something that is good if you're working in IT, to identify who are we working with, an IT support and IT suppliers, etc. So you need to update those agreements. And also update your IT policies. So then you will fight the evil off. That's my thought with this picture. So that's all from me. Thanks.
Thank you, Marielle. Very nice presentation. Thank you. And now for some questions.
Hi. If you break out data so it doesn't point at a specific individual, like a group, for example, year of birth or city, is that still illegal?
As long as it can be connected to an individual's personal data. So, for instance, I will answer like a lawyer, like it depends. That's our standard response to that. Year of birth. That's not. We could all be now. I guess we're not born in the same year, all of us. But that's not typically not personal data. But an address could be, for instance, even if it goes to a building like lägenhet, so apartment building, it could actually be personal data. So that needs to be assessed for every kind of data and every purpose, and how to use the data. Yes.
There was a question around here, was it?
Many questions.
I had a question about sensitive data.
Yes.
You mentioned it briefly, like political preferences, race, and sexual preference, and so on. Do you need approval for storing that kind of data? And can you elaborate something on the? You said something about additional security for that kind of records.
Yeah, I can't dive into the security exactly what will be needed, like you might understand, but at least for sensitive data, you don't always need consent. For instance, if you're a hospital, you don't need consent. But for companies, they need consent, and the requirements on consents are actually higher than, for instance, on a regular consent for direct marketing. That's so good because you always need consent if you want to do that for a longer period. It needs to be the explicit consent instead of just consent, and that is also something that we discuss a lot at our office. What does it mean with an explicit consent compared to a consent when you do it online? So there are harder requirements on that. Definitely, and if your email needs to be encrypted, for instance, for sensitive data, you can't just send it over Gmail or regular mail. And that's how, if you think how hospitals, if you know anything about hospitals, how they work today, that's, for instance, that's a good starting point, how they work with sensitive data. Did that answer your question?
Yes.
Yeah. Thanks.
So I want to ask about old legacy systems. Are you actually saying that this GDPR will apply also for legacy systems, right?
Sorry, by legacy systems you mean old systems?
Yeah.
Yeah. No, that's not the point, or that's not the thought behind the GDPR. So all companies doesn't have to throw out all the old systems now. But of course, this is a hard question because you need to comply with the law, and you can't say, well, our system in 10 years, our system doesn't support that. Somewhere they have to draw a line, I think. But all companies doesn't have to purchase new systems. But if you do, or if you design new systems, you need to have this in mind. We'll see from there will be guidelines, etc. So we don't know the details yet. But it's unreasonable if it should mean that all companies should throw out their systems and buy new ones.
So there will be some migration.
Yes, but not for new systems. Well, a lot of questions.
Yeah. Have you seen any practical examples when it comes to the right to be forgotten? I was thinking about that you have things that you have to store, like repurchase, billing, and so on, and it could basically be shared for different purposes, data. Have you seen any examples how you differentiate maybe a key data on personal information compared to data that's also used for marketing and so on, since you need to store maybe some information for other legal purposes?
On the security requirements, or?
Yeah, on the GDPR, the right to be forgotten.
Yeah.
If it has several different purposes and can be used for different purposes, but still you need to keep it for other
Yeah.
ones.
Okay. Yeah, that's a good. For instance, then let's say bokföring. I don't know the English word. Well, accountant. Okay. If you need to follow the law, you need to save some data for 7 years, for instance. But for direct marketing purposes, unless you have consent, you can only save information for 1 year, and that could be the same data. Yes. So one difference under the GDPR and also actually under current law is that should not be in the system where anyone can search, and in the searchable system, if you know what I mean. And so if one purpose is direct marketing, of course people working with direct marketing should get access to the system, and it could be in a CRM system searchable. But if you need to save it for 7 years for accounting purposes, then it shouldn't be searchable in the system, for instance. That's one easy example. Did that answer your question? Partly, yeah. Yeah. Yeah, that's a conflict between. No, unfortunately not. But there is a conflict, and then it's also a risk. There's a risk. Well, we don't have security log or backup logs or whatever it could be against the GDPR compliance. These will be in conflict, and that's something companies need to work with and assess what risk are we willing to take. Because there is no guidance now that says, well, you can keep security, backup logs, etc. For a longer period of time, even though it contains personal data. But if you can anonymize the data or use personal data on an aggregated level, of course, that's different. Then it's not personal data anymore. So I think that will be the way forward, if it's possible.
Hello. I have a question about what if there's laws in conflict with GDPR, like the bokföringslagen and the archive law?
That's a good question. There's actually an investigation going on right now where the legislator is in Sweden is investigating how it will be working together with the GDPR. Now, PUL, Personal Data Act, is subsidiary to all legislation. Maybe you know that if there is some other legislation which is in conflict with the Personal Data Act, the Personal Data Act is subordinate. But now with the GDPR, that will not be the case, but there are exceptions, of course, so the question is, it depends. But how can I say this? For instance, we still have our grundlag that will be put in first place, for instance. But there's an investigation, and we will see how it will be interpreted.
So, who determines if the anonymization method is appropriate? If it's accepted, if it's valid, who determines that it's okay?
Well, if it's not, the question is rather if it's not personal data, the GDPR is not applicable. So that's. But I don't know if I understand the question entirely.
So, if let's say if I can anonymize data, so it's no longer personal data.
Yes.
It works, right?
Yeah.
It's accepted, but how can you make sure that when the data you anonymize is no longer personal data and you can be sure of it? Who actually validates that this method is correct?
Well, we have supervisory authorities that will supervise the GDPR compliance, and then there will be also all the national supervisory authorities will come together to a data protection board, which will also supervise the GDPR. But it should be. Your question is if it's not completely anonymized, then it is personal data.
Thank you. According to the wording of the current law, PUL, it is only personal identifiable information if it's about any now living person. So my question is, under the new GDPR, does it stop being personal information if that person dies?
No, it still has to be a living person.
Okay.
Yes.
Thank you.
Last question.
Ooh, exciting. I will be here for a while afterwards if you want to ask me some questions, of course.
Yes, does this apply to all systems, or does it also apply to personal non-profit projects that you do at home?
Well, for strict personal use, it doesn't apply, but it depends. Now, for personal use, of course, you can process personal data, but for non-profit associations, for instance, they must definitely apply these rules on their systems. Yes.
All right, so it's wonderful that there's so much interest in this topic, but I'll
be back next year now.
Yeah. But we're 7 minutes over time in the coffee break, so go out, have a coffee, have some refreshments, and thank you, Marielle.
Thanks.